The two higher levels of the scheme for supporting and protecting vulnerable children are support that can be provided to looked after children and then support that can be provided to children in care. Now I'm going to skip up to the last of those steps, children in care, and then come back to look at looked after children, because some of the although the terms are often used interchangeably, children in care, looked after children, they do mean slightly different things. But the term looked after child covers those who are in care, but also those who are accommodated by the local authority under Section 20 of the Children Act 1989 as children in need. So we'll deal with all of those together as looked after children once we have looked briefly at what we mean by a child in care and how a child comes to be a child in care. The important legislation for children in care are parts 4 and 5 of the Children Act 1989. And then we have important legal duties that arise from the Care Planning, Placement and Case Review regulations 2010. There are also 2 pieces of statutory guidance relevant to children in care, and those are the Working Together to Safeguard Children Guidance, which was updated in July 2018, and the Children Act 1989 Guidance and Regulations Volume 2, which relate to care planning, placement and case review. So those are called the care planning regulations. As with other areas that we've seen in our scheme of support, to become a child in care, it always starts with an assessment. And the assessment that's relevant for children who become a child protection concern and who the local authority considers might need to be taken into care is an assessment under Section 47 of the Children Act 1989. And this section says that local authorities must undertake inquiries, but by that we mean must do an assessment, where they have reasonable cause to suspect that a child who lives or is found in their area is suffering or is likely to suffer from significant harm. This means that Section 47 assessments can be done before a child is born, so there can be pre-birth assessments of a child, and in this context where we're looking at vulnerable mums and their babies, some local authorities operate blanket policies or practices of automatically doing a Section 47 assessment of an unborn child. So when they find out that a looked after child or care leaver is pregnant, they will do an assessment to determine if that child is suffering or is likely to suffer from significant harm. This practice is slightly problematic in that those automatic decisions that a child is likely to suffer from significant harm, an unborn child, based solely on the mother's status as a looked after child or care leaver, can potentially be discriminatory, as what the local authority is doing is making a judgment purely on the basis of the mother's own status belonging to that group as a care leaver or looked after child, without taking a kind of nuanced analysis to look at the actual circumstances of that young mother and whether they are such that she poses a risk or that her situation poses a risk to the unborn child. So that's something to be really mindful of in this context where these Section 47 assessments are being undertaken or are being contemplated by a local authority. Before doing a Section 47 assessment, the local authority social services should convene a professional strategy meeting. And in this meeting, the timescale to set out, to complete the assessment should be set out and agreed by professionals. Now, the local authority have as much as 45 working days to complete the assessment, and that timescale comes from the Working Together guidance. And as with a child in need assessment under Section 17 of the Children Act, if the local authority depart from that timescale, if they take longer than that, they need to be able to provide good reasons to justify departure from that timetable. In reality, Section 47 assessments are often done much more quickly, and the strategy meeting will agree how quickly they need to be done. The reason that they tend to be done more quickly is because those assessments are only done where the local authority are concerned that a child may be at risk of significant harm or is suffering significant harm. So in those circumstances, it would be inappropriate to necessarily sort of take as long as the local authority have legally got, i.e. that 45-day working day window, because some situations are such that the local authority need to assess what's going on straight away and then potentially to act straight away. The purpose of a Section 47 assessment is for the local authority to decide whether their concerns about a child are substantiated. So they can only do a Section 47 assessment where they consider, where they have reasonable cause to consider that a child is suffering or is likely to suffer from significant harm, and they can. And the point of the assessment is then to go on to decide if that reasonable cause exists. So if those concerns are genuine and are substantiated and are borne out by the information gathered in the assessment. The local authority is required to do a detailed enough assessment that they can decide what type of action is needed to safeguard a vulnerable child. The outcome could be that they consider that an application to the court for a care order is required. So they might think, having done a Section 47 assessment, that this is a child who, in their view, should be taken into care. And where that's the case, they need to be making an application to the court for a care order. And that's the family court that they will apply to. It could, however, be that the outcome of the assessment is that they have a duty to exercise other powers or duties in the Children Act. So that means that one outcome of a Section 47 assessment is that they might find that they have a duty to provide that child with Section 17 services as a child in need, or they might find that that child is a child who would benefit from early help services. So just because a Section 47 assessment is being done, it doesn't necessarily follow that the conclusion will be that the only way to provide support at the end of that will be through child protection processes and through seeking to remove that child from the family's care. It could be that the local authority could provide services or support to safeguard a child by way of putting in place support at one of those lower levels of our overarching scheme, so early help or child in need level. This means that even at this point, it can go either way. So it shouldn't be assumed that a Section 47 assessment leads to a child protection plan. It should always be entered into by professionals, by social workers doing the assessment, as a kind of open process, which could lead to provision of other kinds of support if needs are identified. Of course, it could be that no needs are identified whatsoever, in which case no further action would need to be taken. As with child in need support, a child in need assessment, the Children Act itself doesn't tell us what a lawful Section 47 assessment is, but again, the Working Together guidance and the courts have provided useful guidance about how a Section 47 assessment should be completed. The Working Together guidance tells us, for example, that the Section 47 assessment must gather all relevant information to be able to fulfil its purpose. including information gathered from the family, from the parents, from other relatives who might have important information. The purpose of the Section 47 assessment is to establish if the local authority's concerns that a child is suffering or is likely to suffer significant harm are borne out. So the local authority needs to do a detailed enough assessment and gather enough information to be able to make a decision about that. The working together guidance, the triangle that we talked about earlier when we were looking at child in need assessments, applies equally to Section 47 assessments, which means that the kind of considerations that the local authority should be taking into account are quite wide-ranging, as factors to do with a family's financial circumstances, access to social network, for example, are relevant, as are issues around parenting capacity and other factors. And as with a child in need assessment, there is no hierarchy of these different factors when a Section 47 assessment is being done. So really an assessment should look at all of these areas as part of the analysis that enables a local authority to reach a view about whether a child is suffering or is likely to suffer from significant harm. If the local authority decides that a child is at risk of significant harm or is suffering from significant harm, then the local authority can apply to the family court for an emergency protection order, which is a care order that's granted for a limited period of time. And in each order, the court will specify how long this is being granted for. And it might be that an emergency protection order is sought to enable the local authority to gather more information or to do a more detailed work with the family and with the child before applying for a full care order. The effect of an emergency protection order is that a child can be removed from the family and placed elsewhere in the care of foster carers, another relative, for example, or in a children's home, depending on what the local authority deem to be appropriate and what the court authorises as an appropriate care plan for that child. The court will only make a final care order at the end of care proceedings, so after all of the evidence from the local authority about a child's risk of harm has been submitted, and after the parents of that child and any other relevant parties have submitted their evidence, and all of that's been considered by the court. The court will only then go on to make a final care order under Section 31 of the Children Act 1989 if it's satisfied that the child is suffering or is likely to suffer significant harm, and the court has to be satisfied that that harm is attributable to the care given to that child or likely to be given, not being what it would be reasonable to expect a parent to give that child, or if the child is beyond parental control. That's interesting because what Section 31 says is that you only have to be a reasonable parent. So if your child, in order for a care order to be made, has to be suffering or likely to suffer significant harm, and you need to not be providing a reasonable standard of care to that child, you don't have to be the best parent that there is in order to avoid your child being taken into care. You have to be a reasonable parent and provide a reasonable standard of care. And I think that's really important when we're thinking about our young mums, because in our experience through the MAP project, often they are sort of held to a standard that is significantly higher. They're asked to do things or expected to conduct themselves in a way which most parents aren't or don't have such high expectations. So it's really important to to think about what young mums are being asked to do, how they're being treated by the local authority, and and think about potentially whether what they're being asked to do is more than the average parent is being asked to do. That might be relevant if it reaches a stage where care proceedings are issued, as as an important point to raise in relation to those. At this point, it's also probably worth saying that the guidance to the Children Act, so the guidance about care planning, says that where compulsory intervention in the family life is necessary, and by compulsory intervention we mean the issue of care proceedings, so a local authority removing a child or seeking to remove a child from the family. The guidance tells us where compulsory intervention is necessary, it should be done to support rather than undermine the parental role. Again, I think that's really interesting to think about when we're dealing with young mums who themselves have been looked after or are still looked after, because care proceedings, the issue of care proceedings, is a very extreme step for a local authority to take. They have to consider there to be reasonable cause to suspect a child is at risk of significant harm or is likely to suffer significant harm or is experiencing significant harm. That local authority really does need to be thinking about the purpose of issuing care proceedings. Are they they've identified that the child may be at risk of harm, but is the way to support that child and to support the family by issuing care proceedings? Or is there another step that can be taken through provision of early help, child in need support? Really important that these considerations are looked at, because of course if the local authority are doing something which goes beyond what would be necessary to protect the rights and freedoms of that child, then there could be an unlawful interference with the family's private and family life under Article 8 of the European Convention on Human Rights. And that's something we were talking about at the outset, that balance has to be struck between the rights of mum, private and family life, and the rights of a child. And this is no more evident than when we're thinking about the issue of care proceedings and seeking a care order which would permanently place that child in the care of the local authority. Now, I said that the term looked after child is sometimes used interchangeably with the term child in care, but that it's something different. Well, the reason it is something different is because the term looked after child refers to a child who is in care, so who has been subject to a care order under Section 31 of the Children Act 1989 by the Family Court, or a child who has been provided with accommodation by the local authority social services under Section 20 of the Children Act 1989. So a child who is a child in need, who's been provided with accommodation through the voluntary care scheme that we talked about earlier, i.e. where a parent has consented to the local authority accommodating their child. In relation to MAC project work and the young women that we've worked with, we've seen situations where both the mother and the child could both be looked after children. So, for example, a mother might be subject to a care order and her child may be accommodated under Section 20 of the Children Act. Both of those are looked after children for these purposes, and the local authority will have equal duties towards them as looked after children. The duties that local authorities have towards looked after children are really, really extensive and come from all from a wide range of legal provisions, including sections 23A to 24D of the Children Act 1989, the Care Planning, Placement and Case Review Regulations of 2010, the Working Together Guidance again, the Children Act 1989 Guidance and Regulations Volume 2, which is the Care Planning, Placement and Case Review Regulations, or the Care Planning Regulations we call them, the Children Act 1989 Guidance and Regulations Volume 3, which are Planning Transition to Adulthood for Care Leavers. So the leaving care regulations also contain details of duties that local authorities owe towards looked after children. Now, bearing in mind that in order for a child to be removed to the care system, the court has to be satisfied that the care being provided to that child by their parent is not of a reasonable standard, so the parents only need to provide a reasonable standard of care to their children. The local authority's duty as a corporate parent, which means the local authority's duty towards children that they look after, is much higher. So local authorities have to provide the best possible care that they can to looked after children. The corporate parenting principle, we call it, says that the role of a corporate parent is to act as the best possible parent for each child they look after and to advocate on his or her behalf to secure the best possible outcomes. So whereas a private individual as a parent, whereas our mums only need to provide a reasonable standard of care to keep their children, the local authority, once they are looking after those children, have to provide the best possible care. Children who are looked after by the local authority have a number of really important rights. These include the right to be accommodated and maintained. Maintained means supported financially. It can also mean being supported with things like access to appropriate clothing, travel expenses, so maintained in other ways aside from just financially. The local authority also has to ensure that looked after children are provided with appropriate advice, support and assistance where needed. And that means access to things like information from, it could be about all manner of things. Access to advocacy can sometimes include access to legal advice or access to support around things such as health advice. So, for example, if they looked after a child, if our mother, if our mums are looked after children themselves, if they're still under the age of 18, they might need to access appropriate advice around their sexual health or around contraception. That could all be advice that the local authority, as their corporate parent, might have a duty to ensure that they can access. Looked after children have rights to have their wishes and views taken into account. This is more significant when we're talking about older looked after children rather than when we're talking about babies. But the older a looked after child is, so again, if our looked after child is our mum, then her wishes and feelings should certainly be taken into account. They're not determinative, so ultimately it's the local authority's responsibility to make decisions about what will be in that child's best interests. But the local authority can't ignore what a young person is saying about what they want, what their preferences are, what they don't want. And even younger looked after children, whilst they might not be able to articulate completely or understand the kind of nuances of different options that they might have in terms of how their care is delivered, they might be able to express preferences, and the local authority should record and give weight and consideration to those preferences when they're making decisions about how to care for a young child. Looked after children have a right to have regular reviews of their care. These are called LAC reviews, looked after child reviews. And these reviews should be chaired by an independent reviewing officer rather than by the child social worker or the child social work manager. The reason is that the independent reviewing officer has to really investigate how the care is being delivered, how well the care plan's working, and challenge any aspects of it that don't seem to be working well for that child. There are a number of really detailed procedural safeguards set out in the care planning regulations about how LAC reviews should be conducted and what should be considered as part of these. Looked after children also have a right to have an advocate to assist them in making representations in LAC reviews and to assist them in making complaints. Now, local authorities sometimes interpret the term complaint in a quite restrictive way to include only a formal written complaint made through the local authority's complaints process. But actually the guidance to the Children Act, the Working Together guidance, suggests that the term complaint should be interpreted much more broadly, and it's an expression of dissatisfaction. So where you've got a young person saying, I'm not happy with this placement, I really dislike this foster carer, it's not working for me, I'm not getting on well here. Those are expressions of dissatisfaction which could well trigger a right for that young person, for that child, to have a statutory advocate appointed to them to help them make representations to the local authority about what they want and what they're unhappy about. Local authorities have a duty to accommodate looked after children, and they have to consider very carefully how they do this. And before providing accommodation to a looked after child, they need to consider the child's wishes and feelings about a particular type of accommodation or a particular placement where that child's old enough to give their wishes and feelings. They also need to consider a parent's wishes and feelings. So where we're thinking about looked after children who are, babies or children, and young mum is parent, the local authority must, in deciding what kind of placement a child should be provided with, consult mum. And that requirement comes from section 22(4) of the Children Act 1989. The local authority then has a duty to place the child with their parent unless it would be inconsistent with the child's welfare or it's not reasonably practicable for them to do so. If they can't place a child with their own parents, then they need to look for the most appropriate alternative placement. And the care planning regulations set out a hierarchy then of appropriate placement. So if a child can't be accommodated with their parents, they should be accommodated with another relative if at all possible, or another a friend or somebody sort of associated with the family. If not, the local authority can start thinking about foster care placements. If that's not appropriate, they can start thinking about children's homes, etc. But they can't jump straight to a children's home or a secure accommodation placement. They need to be looking at alternatives first. And that hierarchy really emphasises the importance of trying to keep a child in a sort of natural family environment insofar as possible. For many looked after children, the vast majority of looked after children, I would say, those placements are considered to be more appropriate than seeking to place a child in a kind of more artificial environment like a children's home. The care planning, placement and care review regulations and guidance also tell us that local authorities have a number of other duties towards looked after children when they are deciding how to support them. So they must ensure that a child has a care plan at all times. As with early help with child in need. It's no different for looked after children and children in care. There should always be a plan in place that sets out what support's being provided to them, by whom, how that support's being provided, and what purpose it serves. And for looked after children, that plan is called a care plan. The plan should include arrangements for meeting needs relating to family relationships. And this is a really important provision that we find under Regulation 4 of the Care Planning, Placement and Care Review, Case Review Regulations, beg your pardon. It's important for our mums because if the looked after child in question is their child, their baby or their child's care plan should include details as to how the local authority is going to support that child developing, maintaining a relationship with mum. So that might be through contact, it might be through parenting, capacity work with mum, but the local authority should be seeking to consider that as a vital part of the child's care plan. The child should always be given a copy of their care plan. If they're old enough, obviously, to understand it. If not, their carers should certainly have a copy. The parent should also be given a copy of that care plan. So again, if the looked after child in question is the baby, is the child, and our young mum is the parent, then she should have a copy of the care plan as well, unless the local authority considered that it would put the child at risk of significant harm to provide that plan to mum. The circumstances in which that's going to be the case are quite rare. So in most situations, a parent should be given a copy of the care plan of their child if their child has become looked after. A child who is a looked after child should also, in addition to a care plan, have a separate plan called a placement plan, which sets out how the placement that they're currently in meets their needs and takes into account their wishes and feelings. So a looked after child should always have the care plan and the placement plan, and both of those documents the child is entitled to a copy of. The local authority has to ensure that a looked after child is given a voice in the process of being looked after. You've probably in your professions come across the phrase "the voice of the child." It's something that is sort of often quoted in cases in the media, in local authority publications, in government publications. The voice of the child is seen to be very important. And for looked after children, Schedule 7 of the Care Planning, Placement and Case Review Regulations says that local authorities are required for looked after children to ensure that the children are given a voice in the process. This is where advocacy comes in. If a young person needs support to articulate or communicate what their wishes and feelings are effectively so that they can contribute to a process, then the principle that that voice of the child is heard requires that local authorities do ensure young people are given the opportunity to engage fully with the local authority and with the processes that they are subject to. Looked after children have, I've explained that they have a right to have LAC reviews, so their care should be considered by an independent reviewing officer on a regular basis. And the Care Planning, Placement and Case Review Regulations set out exactly how often those LAC reviews should take place. This largely depends on how long a child's been in care, how sort of stable the placement is. But initially, within a new placement, there should be a review within 2 days, and then 3 months later. And then after that, it might progress to being once every 6 months that a review of care is carried out. That's just a sort of overview of some of the key provisions in those regulations, but local authorities have really extensive duties towards looked after children, and that's So that's not an exhaustive list. Those are just some of the really key provisions that are relevant to our young mums who are themselves looked after or have been looked after, and their children if their children become looked after.